stacking, what we've seen is a drastic rollback in three major areas of our civil rights. The most important and significant is the ability of Congress to pass laws, really challenges to the authority of Congress to pass certain key legislation. The second is challenges to the authority of Congress to subject the states to those requirements. In other words, if Congress has the power to pass a law, can you make the states accountable? And then the third is, if you have the power to pass a law and you can subject the states to the requirements, can you even get into court to vindicate those rights? The first one, again, the reason I say that's the most significant is because if Congress doesn't have the power to pass laws, that undercuts the very validity of existing civil rights laws themselves. And the key case in this area is United States versus Morrison. It was a 5-4 decision, and pretty drastic facts in that case. Christina Brancala was a student at Virginia Polytechnic Institute. She was gang raped by several of her classmates, and the school didn't take any action against them. In fact, the students stayed in the school, they continued to harass her, and the only thing she could do was go to court and bring a claim under the Violence Against Women's Act, which is a federal law that allows you to assert a claim in federal court against perpetrators of violence against women. What the court did in that case was very shocking to many court watchers, but the court went in and said that violence against women wasn't substantially enough connected to interstate commerce. So they didn't have the authority under the Commerce Clause to pass it. But then they went a step further and said they couldn't even pass it under the 14th Amendment, Section 5 of the 14th Amendment. And that has an effect in all types of different areas of key civil rights legislation. That second point here, the ability to subject the states to the requirements of federal law, is also very important. Another sad case, Patricia Garrett in Alabama was a nurse. She got breast cancer, and as a result, her hospital started to discriminate against her. They demoted her, they moved her to another job, and the only thing that she could do, again, was go to federal court under the Americans with Disabilities Act. Again, it worked its way up to the Supreme Court, and the court said no. Regardless of the merits of the case, Congress could not subject the state to the requirements of the ADA. And that has a spillover effect in a host of other areas. The third is this ability to get into court. A key case, again, out of Alabama. And again, it's a 5-4 decision, rolling back our rights. It's called Sandoval. It's a case that has to do with an English-only law to get a driver's license in Alabama, and it guts a major piece of the 1964 Civil Rights Act called Title VI. Basically what it means is you can no longer just have disparate impact on a community of color. You actually have to show intentional discrimination. And there are a couple of other key cases in this area that limit a particular statute called 42 U.S.C. 1983. It's a long name for a statute that basically is just a vehicle to be able to get into court and assert your federal rights and your civil rights. But that's been really hampered through a series of cases, one from out here called Gonzaga v. Doe. These are sort of the three major areas of the rollback, but there's sort of a catch-all fourth area. I don't really even know what to call it. It's basically an avalanche of cases that are starting to come down from the Supreme Court that are really rolling things back. And you all must be very familiar with the first one, the Seattle and Louisville school cases. This is really a big rollback in the area of integration. Last term, in a 5-4 decision, the court said that Seattle's very modest efforts to integrate our schools is unconstitutional, basically turning Brown on its head. No longer can you challenge certain actions that violate the separation of church and state, standing requirements. This third one is one of the hardest things to explain. It's a case called Buchanan, which limits attorney's fees. A lot of folks think, oh, well, the attorneys are getting too much money anyways, or they're not important about the fees, but you can't go into federal court and litigate unless you have a lawyer to help you, and a lawyer's not going to be able to help you if they can't get fees, because how are they going to keep the lights on? And a host of other areas, mandatory arbitration, basically waiving your rights to get into court. You have to go to an arbitrator in employment disputes and other areas. The Americans with Disabilities Act is terribly difficult now to bring a claim under because the definition of disability is so tortured. Limits to free speech and a whole other area called qualified immunity. So these are a whole avalanche of cases, especially in the last couple of terms that we're starting to see.